Today is Tuesday, June the 13th, 2017. It's 10 a.m. It's my pleasure to call to order today's meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Ms. Lisa Mosby, will you please call the roll?
Dennis Bridges.
Here.
Mark Cawthorn.
Here.
Robert Davis. Jeff Duffer.
Here.
Robert Helms.
Here.
Clark McKinney.
Here.
Charles Rahm.
Here.
Mr. President, we have 6 of the 7 board members present.
Thank you, Ms. Mosby. First item is to welcome our new board member, who's actually not very new, but Mr. Mark Cochran has been reappointed to the board for another term. Mark.
Very nice to be back. Thank you.
Congratulations.
Good to
Thank
keep
you.
you on the board.
I appreciate it.
We have the agenda in front of us.
Motion to approve.
Second.
A motion by Mr. Duffer, second by Mr. McKinney. All in favor say aye.
Aye.
Opposed? The minutes are also on your iPad, and were also forwarded earlier.
Motion to approve.
Second.
Then a motion by Mr. Rahm, second by Mr. Duffer. All in favor say aye.
Aye.
Opposed? Okay, legal report, Ms. Allison Renfro.
Good morning.
Good morning.
First of, I think, about 18 cases on the legal report is case 2017-004531, 2, and 3 against an establishment, embalmer, and funeral director. This complaint was filed by a former employee of the establishment and stated used hospital body bags were being used as casket liners so that the casket could be reused and not damaged, and that complainant took about 20 remains out of the same burial casket since July of 2016. The complaint also stated that the funeral director embalmer would instruct complainant and his coworkers to take the remains out of the casket, lay remains on a table, zip up the body bag, and write the deceased name on the outside with a permanent marker. The remains would then be placed in a storage room by the chapel until the remains would be transported to the crematory. The complaint further states remains stayed in the storage room over 2 weeks, and if space is limited, employees were instructed to stack the remains on the same table on top of one another. Upon investigation, the complainant stated that when he began his employment with the establishment in 2012, the funeral director embalmer instructed him to wrap the remains in plastic prior to dressing and placing the remains in a casket, and after the visitation and/or services, the remains were removed from the casket and placed on a dressing table prior to being taken to the crematory. If the casket's interior was soiled, funeral director embalmer had instructed complainant to clean it and use Febreze. Complainant stated that the procedure had changed in 2016, where a white vinyl hospital body bag was placed in the casket prior to placing the remains in the casket, and the remains were wrapped in plastic prior to the dressing and casketing. Complainant stated that after services and or visitation, the remains and bags were removed from the casket, zipped up, and placed on a dressing table. The name of the decedent was written on the body bag and placed in the storage room with no ventilation and stacked on the tables. Complainant states that he was instructed by funeral director embalmer to reuse the casket on numerous occasions as indicated by the photos in the complaint he provided. The owner of the cremation company that performs the cremations for the establishment stated that bodies are usually delivered in fiberboard containers, cremation tray, casket, casket insert, or a stretcher, and are usually not delivered in a body bag. The owner stated if the body is brought in on a stretcher, the body is placed in an alternate container. In the file, 31 of the cremations were noted as being in an alternate container, and only one was the body bag of the remains of an infant. An employee for the crematory stated she does not recall bodies arriving from the establishment in plastic bags. The funeral director embalmer stated that when a family requests cremation, the casket is lined with a white hospital body bag prior to placing the body in a casket. He further stated that the storage room that stores the bodies prior to transportation to the crematory is usually cool but does not need ventilation because the bodies placed in the room are embalmed and dressed. He stated the room is locked and only accessible by staff with a key kept in his office. He stated the bodies are stored in the room either in a casket, alternate container, and if they are in a body bag, each body bag is on a separate table. During the investigation, the storage area had one body in a shipping container ready to be sent to the airport. He expressed concern that complainant would photograph the remains without permission and make false allegations. The funeral director and embalmer did not have invoices for hospital body bags because these bags are often complimentary from companies the funeral home works with, and does not have invoices for a rental casket, and explained the charge for cremation included cost of using the casket to provide families of limited means with a dignified service. The investigation concluded that it was undisputed the funeral director, embalmer, and establishment used the same metal casket without a new interior or interior insert being installed prior to each usage of the casket shell. Therefore, it is legal's recommendation that the establishment receive a consent order with a $2,000 civil penalty and authorization for a hearing. The factors for the basis of the civil penalty are the number of incidents, the circumstances leading to the violation, the economic benefit gained by the violator as a result of noncompliance, and the establishment's past disciplinary history. This recommendation is $500 for the 4 violations that I've itemized in this legal report. Using any part of a casket that has previously been used for a receptacle of a dead human body, misrepresentation or fraud in the conduct of business of a funeral establishment, any willful violation of a state law or county ordinance affecting the handling of dead human bodies, and that no funeral director or embalmer shall engage in any act, omission, or practice which is misleading or deceptive. Legal also recommends a consent order with a $1,500 civil penalty for the funeral director and embalmer and authorization for a hearing. This recommendation is $500, a violation for the 3 violations I've itemized, which includes the applicant of the holder of the license has been guilty of willfully violating regulation of state or local board of health governing the disposition of dead human bodies. The holder of the license has been guilty of immoral or unprofessional conduct, and that no funeral director shall engage in any act, omission, or practice that is misleading or deceptive.
What this boils down to is they used a casket for a rental unit that was not really a rental unit. They were not replacing the interiors every time they were using it. That correct?
Correct.
Did the board's investigator go out and investigate this complaint?
Yes, it was investigated and the files reviewed. I described as that the investigator did not see any invoices for casket inserts. It appears body bags were being used as the makeshift inserts.
Motion to accept the recommendation.
Second.
Motion by Mr. Rom, second by Mr. McKinney. Any other discussion? All in favor say aye.
Aye.
Opposed? Next, please.
Next is complaint number 2017-00711 and 2 against an establishment and a director. This complaint was filed by a consumer that stated after the complainant's mother died, he contacted respondents, advised them that he would be performing the embalming, and the remains were transported to the establishment where complainant, a licensed embalmer, completed the embalming. The complaint states that complainant realized he had forgotten to provide his embalming number and called respondent to see if he had the number, and respondent was short with him on the phone. Then the death certificate was received by the family, and it had the wrong embalmer's name and number on it. Included with the complaint is the death certificate, and it does not contain complainant's name or license number. Complainant states that he should not have been charged for embalming, preparation of remains, casketing, makeup, and hair. The response to the complaint states that complainant expressed his desire to embalm his mother's remains. We informed him this was unadvisable and were unsuccessful in our attempts to dissuade him. While licensed, complainant had not embalmed anyone in recent years and had to solicit our embalmer's assistance in completing the procedure. Upon completing the embalming, complainant made no mention of his desire to be the embalmer of record at that time, and the death certificate was submitted prior to his provision of his embalmer license number. as the registered embalmer for the establishment and the responsible party. The establishment's embalmer endorses all death certificates for the establishment. Regarding the charges complainant disputes, those services were performed at the establishment using establishment materials. Legal would therefore recommend a letter of warning because in circumstances of this nature, there should be a good understanding between all the parties as to their plan prior to the actions transpiring. Additionally, the name and license number of the registered embalmer for the establishment should not automatically be listed as the embalmer on certificates for death. The embalmer actually embalming the remains should be on the license reflected on the certificate of death.
Did the family give permission to embalm?
The family communicated with the establishment that this person expressed his wishes to embalm his mother's remains, and there's some back and forth, nothing in writing, and so in a verbal agreement that he was going to embalm the remains, but apparently embalmed them on the establishment property with establishment materials and with the help of the establishment's embalmer. Yes.
Motion to accept recommendation.
Second.
Motion by Mr. Rom, second by Mr. Duffer. All in favor say aye.
Aye.
Opposed? Next, please.
Next is complaint number 2017-008-081 against an establishment. Upon inspection on January 17th, 2017 of the establishment files, it was determined that 4 files had forms that were not signed and dated by a licensed funeral director as required by law. Also, the reason for embalming is required on contracts, but of the files reviewed, one statement of funeral goods and services selected contract did not have this information completed. The response stated the contract has been corrected so that it now states a reason for embalming. The 4 forms are now signed and dated, and these responses were included to show the proof of the corrections. Legal therefore recommends a consent order with a $250 civil penalty and authorization for a hearing.
Move to accept council's recommendation.
Second.
Question. The 4 forms, are you able to identify the 4 forms that were not properly signed and dated?
They would be in the file, which I have not brought down with me, but can certainly go get them.
It's my recommendation, or not my recommendation, it's my recollection that those forms were authorizations for cremation.
Other questions? Mr. McKinney made the motion. Got a second, Mr. Cochran. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Next, please.
Next is complaint number 2017-008841 against an establishment. This establishment was issued a notice of violation on March 16, 2016 from a board field representative. The notice of violation stated the order must be complied with on or before 20 calendar days, but over 5 months passed with no response from the establishment. The violations listed on the notice of violation are as follows. The general price list fails to list basic services of a funeral director and staff as an included item under direct cremation as required by the funeral rule. 3 of the 16 required items on the general price list included a $95 charge listed as an archive fee, which the funeral director stated was a fee. This fee was non-declinable as it was itemized into the charges listed for. The director states that the fee for basic services of funeral director and staff is the only non-declinable fee allowed for services facilities or unallocated overhead, and other than a basic service fee, a separate fee cannot be charged for overhead. In the response, the establishment manager corrected the general price list so that basic services are included with the direct cremation price. The archive fee has been removed from the general price list. They included the corrected general price list with its response.
5 months later.
Yes, there was quite a delay in responding to the notice of violation, and that affected the recommendation, which is a civil penalty of $500 and authorization for a hearing.
Motion to accept council's recommendation.
Second.
Got a motion by Mr. Duffer, second by Mr. Bridges. Question?
In regards to their history, the other type of
I don't recall what the prior consent orders involved.
certainly got a history, no doubt.
Yes, they do.
We had the original motion by Mr. Duffer and second by Mr. Bridges. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Next, please.
Next is complaint number 2017013051 against an establishment. This complaint was filed by a consumer who states her husband had prearranged his funeral and paid for his cremation with a specific funeral home. The complaint states an employee of that funeral home told complainant that the establishment, the respondent establishment here, contacted him to inquire if the obituary was going to appear in the newspaper, and the employee advised the establishment that the newspaper had been contacted, he was waiting to hear back, and that he was not the next of kin of the deceased. Complainant received a text from a family member that there was an obituary on social media, and it wasn't the obituary she approved, as the obituary posted had her husband's name spelled wrong and words deleted, as someone had tagged this incorrect obituary to her husband's social media page. Complainant then received a call asking her what was going on because the posted obituary posted a service time and date, whereas she had not determined the day and time yet since her children were out of the country. Complainant states that she is emotionally distressed from dealing with the obituary that was released without her permission. Complainant spoke to an individual at the establishment and asked why did they release an obituary without her permission, as the establishment was not handling her husband's arrangement, yet it still appears if you Google her husband's name. The establishment responded it was contacted by the decedent's mother to conduct a memorial service for a decedent where there would be no physical body or remains present, only a photograph, as she wanted local family and friends to attend a service in the city where her son grew up, understanding that his wife would have a celebration of life for him at a later date. The establishment announced the service on its website, as was their standard protocol. Decedent's mother called the funeral home and was working with decedent's wife to see if they were going to run an obituary in the local paper. Was advised the local paper had been contacted, but did not advise that they were not dealing with the next of kin, as was stated in the complaint. The establishment was later contacted by complainant, who was disrespectful in her request for them to remove the information from the website, which they did immediately after she called and made her demand. Legal recommends closing this case.
Second.
Motion, Mr. Ron, second by Mr. McKinney. All in favor say aye.
Aye.
Opposed? Motion carries. Next, please.
Next is complaint 2017015521, 2 and 3 against an establishment, embalmer, and funeral director. This complaint was filed by a consumer who states her grandfather had a funeral service at the establishment on January 17, 2016. Complainant alleges the funeral director treated her grandmother like she was a stranger to her grandfather, yet they had been happily married for 45 years. Complainant states she took care of her grandparents in Tennessee for 6 years, then moved to Colorado with her grandmother, and her grandfather elected to stay in Tennessee for a little while he was put in a hospital without her consent by his brother. When he passed away, complainant's grandmother was notified the funeral would be in 1 week. The grandfather's possessions were given to the brother by the establishment staff, and the funeral director treated the grandmother rudely. In its response, the establishment stated complainant was the decedent's wife's granddaughter, but not a blood relative of the decedent. The decedent was married to complainant's grandmother for 45 years, but they were separated for 20 or so of those years. The brother furnished a home to the decedent and his girlfriend rent-free for some time. At some point, the girlfriend left, and his wife and her granddaughter, the complainant, came to live with them for a period of time. Decedent had health problems, and when he was in the hospital, his wife visited him one time, took money out of the bank account, and then cleaned out his house and sold its contents. The funeral director did not know who decedent's wife was, but extended to her warm greetings, as is his policy, and pushed her in a wheelchair without knowledge of her identity. After the funeral service, the funeral director gave a bag of acknowledgement cards, sympathy cards, and thank you cards to the brother, who paid the funeral expenses and was the only family member of whom was present for the funeral service. There were no personal belongings in the bag. The funeral director has been in business for 25 years, and this is the first complaint against him. Recommends closing this complaint.
Motion to accept council's recommendation.
Second.
Motion by Mr. Duffer, second by Mr. McKinney. All in favor say aye.
Aye.
Opposed? Next, please.
Next is complaint number 2017015551 against an establishment. This complaint was filed by a consumer who states he found out through social media that his mother-in-law had passed away on February 27, 2017, so his wife contacted the establishment to see if the body was ready for viewing and was told by the establishment that her family was not allowed to come to the establishment due to an order that had been filed by an attorney. The funeral director advised complainant, his wife, his stepdaughter, and her husband and his stepdaughter were listed in the order, and that he would mail a copy of the order, the funeral program, and obituary to complainant. After contacting a sheriff, complainant found out the order may be a restraining order, so he contacted the county sheriff's office where the funeral home is located to see about the papers, but was told there was not an order with those names. Complainant contacted the county clerk's office, Chancery Court, and General Sessions to no avail. As of the filing of the complaint on March 6, 2017, complainant had not received any of the information he was told he would receive. The establishment responded that the decedent passed away on February 27, 2017. The following day, her daughter, complainant's wife, contacted the funeral home to inquire about coming to the viewing when she was told about a directive her mother had left, which was enclosed with the response to the complaint. The authorized directive states that her daughter, daughter's husband, daughter's daughter, and her husband and their daughter shall now not be allowed on the premises during her funeral or at any time while her remains are at the funeral home. Complainant's wife asked if the establishment could mail her a copy of the directive, and it said it would. She called on March 6, 2017 to see if it had been mailed and was told it had not been mailed yet but would be mailed the next day, and she said to keep the copies at the establishment and she would come by the next day to pick them up, which she did. Legal recommends closing this case.
Motion to accept council's recommendation.
Second.
Motion by Mr. McKinney, second by Mr. Ron. All in favor say aye.
Aye.
Opposed? Motion carries. Next, please.
Next is complaint number 2017018681 against an establishment. After a routine inspection on March 8, 2017, the board field inspector issued the establishment a citation for the following violations. The general price list lists some of the required items starting on page 7, but then lists package offerings and does not list the remainder of the required items until page 16. The custom package sheet lists a selected premium casket, and the value package sheet lists a selected premium casket, but the casket price list and a separate sheet listing packages does not indicate a premium casket definition and price that consumers can view. The general price list contains caskets available in packages but does not reference premium caskets. nor are prices for each casket referenced. Caskets listed under each package name do not coincide with the casket listed on the individual package sheet for economy and basic packages. The statement of funeral goods and services selected for 2 decedents does not disclose, as required by the funeral rule, that the price charged by the establishment for cremation process is higher than the price the establishment paid to a third-party crematory. The establishment further violated the funeral rule by failing to list the crematory fee in the cash advances section of the statement of funeral goods and services selected. In its response, the establishment stated it changed the prices they have used for the past 10 years and included required wording, but not in the order the field inspector told us it needed to be in. The manager accidentally put 2 contracts in the cash advance section, which had been corrected. Legal recommends closing this case with a letter of warning.
In regards to the field rep, was this a new or rep, as this price list apparently had been going this way for 10 years?
I don't know who the field representative was in this case.
It was the same film rep that had been there before. I don't know that the price list had not been changed. I don't know about that, but the field rep was the same. Maybe not for several years, but for the past 3 or 4 years.
Has everything been corrected?
Yes, the establishment provided a corrected general price list with its response.
Motion to accept council's recommendation.
Second.
Motion by Mr. McKinney, second by Mr. Duffer. All in favor say aye.
Aye.
Opposed? Motion carries. Next, please.
Next is complaint 2017-021-3901 against an establishment. This complaint was filed by a consumer who stated multiple issues with the services she received from the establishment. 1. Pricing in the packages. Complainant states the funeral director never offered her anything but package deals and she was never showed a price list. 2. Food. Complainant states the food was not what she ordered. The food was a ham, cheese, and vegetable tray when she had ordered barbecue. The establishment got barbecue and buns upon learning of their mistake. 3. Music. Complainant states when she went to the chapel for the funeral service, an employee told her they did not know what the music was supposed to be. 4. Embalming. Complainant states her husband looked white, his hair was not cut, and he looked disheveled. Her husband's hand was soft and she could move his fingers, and she wondered if he had even been embalmed. She was embarrassed by the way he looked. His hair was subsequently trimmed and makeup applied. 5. Vault engraving. Complainant states she told the funeral director she wanted her husband's name, date of birth, and date of death engraved, and was told that was no problem, and it would either have a cross or praying hands with it. Instead of being engraved, it had peel and stick letters. 6. Plot. Complainant asked the employee if she could hold the plot for her from Friday to Wednesday, but was told no, and that hopefully no one will buy it before she can purchase it. 7. Services received. Complainant states the funeral director who helped plan her husband's funeral told her he would be off work during her husband's funeral service. She was so upset at her husband's appearance, but no one came to check on her to see if his appearance was okay. 8. Obituary. Complainant states that when she got home, she read the obituary and it was wrong, so it had to be changed. In the establishment's response, it addressed the pricing and packages. It said, "We did present the merchandise and packages to make the selection process easier, but at no time told her she had to select a package. The funeral director did give her a price list and reviewed the contract with complainant prior to her signing it. If the family had asked for options other than packages, those options would have been made available. Regarding the food and music, the establishment admits it made 2 mistakes in handling the funeral service. It did not communicate the change complainant made to the catering order, and the wrong food was delivered, but it was corrected within an hour, and complainant was provided free catering, and a staff member accidentally deleted the song selection, but they were able to obtain the correct song selection in time for the service. The funeral director presented the details of the catering order to the family as he understood their order to be, and never heard the family request barbecue. They just told him they wanted to upgrade their package after being shown the basic light reception package. The menu selected was not noted on the contract. The only item that was incorrect was the main dish. Cold meats were ordered, though barbecue sliders were what was wanted, and the side items were correct. Embalming. Upon hearing complainants' issues with her husband's appearances, adjustments were made to his hair and cosmetics were applied immediately. Vault. The vault complainant selected did not offer the option to include full dates. The vault itself could not be engraved, but the nameplate could. Complainant was advised that there were fewer options with the vault she chose. Plot. The family service counselor followed the procedure of holding adjoining plot spaces for family members, and imagined complaint mistook what was said about holding additional spaces. It was never said that the plot would not be saved. Obituary. The draft had one grammatical error but was not put in the paper with the error. The establishment states it is determined they will refund 110% of the service charges, which is approximately $7,441.50. The complainant responded to the response, stating that she was only told that the plot could be held after complainant complained about the situation, so the explanation provided in the response is a lie. Legal would recommend a consent order for $250 and an authorization for a hearing for failure to clearly and fully disclose prices and unsatisfactory service, and would request that proof of the refund has in fact been provided to the family.
Establishment actually refund those service fees?
The board has not received proof that it has been, the refund has been provided. The response just stated that they would be providing the refund in that amount.
Establishment only has 2 consent orders, is that correct?
Yes, it has only received 2 consent orders in the past 12 years.
Are they recent or do you know the dates?
One is from 2005 and one is from 2006.
Motion to accept.
Second.
Motion by Mr. Rom, second by Mr. Duffer. Any other questions? All in favor say aye.
Aye.
Opposed? Motion carries. Next, please.
Next is complaint 2017-0081-3123 and 4 against an establishment, funeral director, embalmer, and employee of the establishment. Pursuant to an inspection in October of 2016, the respondent funeral home and funeral director embalmer were cited for allowing an unlicensed person, respondent number 4, the employee, to engage in funeral directing and embalming without first obtaining a license. The funeral director and embalmer allowed the unlicensed individual to perform said services and execute documents on behalf of the funeral director and embalmer. Specifically, according to the inspector, the unlicensed person was meeting with families and conducting services at the cemetery without a licensed funeral director being present. The funeral home website lists this employee as a funeral arranger, which has since been removed from the website due to this complaint. The funeral home and funeral director responded and stated that the employee has completed his apprenticeship and has been employed with the establishment since 2008. However, the employee has not taken the examination as of February of 2017. The funeral director states in response to the inspection that the apprentice has never worked outside the director and supervision of the funeral director. The respondent cites till a certain legal authority to substantiate their position with regard to the term under direction and supervision of the funeral director. The respondent's position is that direction and supervision does not mean that the funeral director must be present. The respondents provided affidavits and work schedules as proof that the employee never took a family to a cemetery without being under the direction and supervision of the funeral director. The response further provides that the employee was acting under the direction and supervision of the funeral director when he was attending arrangement conferences or attending funeral services. The inspector refers in the report to an internal chart used by the funeral home, which appears to list the employee as a funeral director, but the respondent refute using that as the basis for stating that the employee is acting as a funeral director, stating that the chart is used for internal purposes only. The inspector also made note of the name tags and group photograph for the funeral home, which appears to be generic in nature. The law states that a person must not give the impression that a person is licensed if they are not. In response to the complaint, the title arranger has been removed from employee's job title. The remaining issue is that the employee did execute a cremation authorization form, and the respondent admits to signing the name of the funeral director. However, in response to the inspection, the respondent asked the board to consider the factors outlined in the rules when considering a civil penalty, such as the economic benefit gained from the violator, risk of harm to the public, severity of the violation, whether there have been similar violations, and the interest to the public. The respondents asked this board to consider that the primary goal of the funeral statutes and regulations is to protect the public, and that even if a violation has occurred, the public may still have been rendered a valuable service. Legal recommends a consent order with a $250 civil penalty against the funeral director and embalmer, a $500 civil penalty against the establishment, and a $250 civil penalty against the unlicensed for a hearing.
Sounds like there's not very much remorse in what they've done.
Allison, this embalmer, this employee, was he embalming without supervision? That one piece?
I don't know if the complaint states that he undertook embalming without the license. His activities were mostly signing the cremation authorization form, but I don't recall anything about performing embalming.
It did mention that earlier, is that right? There's so much in here.
Yes, it is. Let's see. They were cited for this person engaging in funeral directing and embalming without first obtaining a license, is what the citation said. He performed services and executed documents, met with families, and conducted services at a cemetery.
There's certainly a history of this same activity, these 7 complaints. Or the consent orders.
They received a letter of warning for unlicensed activity in 2016.
Was that to the establishment?
Yes.
I would, personally, I would like to see the civil penalty against the funeral home raised to about $750.
I would agree.
I don't feel like they didn't learn their lesson the last time, and I don't feel like in their response that they really feel like they've done anything wrong this time.
Another question I have, the cemetery piece. He's going to the cemetery. Is he on the funeral home property? Is that like a funeral home cemetery combination place, or is he going off property without that supervision? I'm just curious.
The inspector noted that the employee was conducting services at a cemetery without a licensed funeral director present. I did not observe whether that meant the cemetery is affiliated with the establishment or not.
Two things probably that the board needs to know. One is, no, cemetery is a separate location because this particular funeral home does not have a cemetery attached to it. So the cemetery, I'm not sure exactly where the cemetery was, but it couldn't be on the same physical location. The other thing that I think the board probably needs to know is the unlicensed activity in letter of warning in 2016, that was regarding a pre-need sales agent, not necessarily a funeral director or an embalmer for unlicensed activity. The pre-need funeral funds report not received by burial services and unlicensed activity letter of warning 2016 under the history. That's seller not being licensed and not necessarily a funeral practicing without a license.
Firm been under the same ownership since 13 through 16 up until today, Mr. Gribble?
Changed ownership, but it's been a period of time, probably about 2013 or 2014 when it changed ownership. I'd have to go check to be for sure. Changed ownership. The manager, it's under the same manager, but the ownership of the firm has changed. But the individual
Day-to-day operation has been under the same
has been consistent since 2013 anyway.
That motion is made into a motion.
Yeah, I need that in a motion. Is that a motion, Mr. McKinney?
Yes, I would make a motion for a consent order with $250 civil penalty against the funeral director, $750 against the funeral home, and $250 against the unlicensed respondent.
We have the motion from Mr. McKinney and second from Mr. Rom. Any other discussion? All in favor say aye.
Aye.
Opposed? Motion carries. Next, please.
The next and last complaint is complaint number 2017-015-871 against an establishment. This is a consumer complaint which alleges that the respondent did not file the death certificate in a timely manner. The date of death was July 20th, 2016, and the certificate was not issued until March 2007 and was signed by the medical examiner on February 22nd, 2017. The respondent filed a response stating that immediately upon receiving the complaint on March 17, 2017, the funeral home contacted the Department of Vital Records and confirmed that the death certificate had been filed. Legal would recommend a consent order with a $250 civil penalty and an author.
Second.
Motion by Mr. Rom, second by Mr. Duffer. All in favor say aye.
Aye.
Opposed? Motion carries. Thank you, Mr. Renfro.
Thank you.
Next item on the agenda will be the director's report. Mr. Gribble.
Thank you, Mr. President. Before you today is first is a performance and compliance audit update. Basically don't have any further information to report than what we did the last board meeting. Since the board meeting on May the 9th, we've not had any requests for information or documents from the auditors. Had a conversation or communication with the assistant commissioner, and he said he had no further information that we could provide to the board this morning, but we'll keep you updated. Hopefully within the next board meeting or very soon we'll have a report on that we can share with you. Legislative update is a notice of law changes. Public Chapter 154 is effective July 1, 2017. Requires that 5 of the 10 heirs of continuing education obtained by a funeral director or embalmer to renew a license must be attended in person, which means the continuing education coursework is completed by the licensee in the physical presence of the provider of the coursework, or is completed by the licensee through an interactive virtual program that requires participants to confirm their presence during the program. This requirement applies to all renewals on or after July 1, 2017. Public Chapter 144, effective April 17, 2017, provides that licensed funeral establishments may be used for providing commemorative services defined as a ceremony for the dead prior to burial, cremation, or any other legal form of final disposition. Public Chapter 158, effective July 1, 2017, sets out requirements regarding the release of remains of a deceased person from a funeral establishment with custody to a second funeral establishment upon request, as well as the responsibility of the receiving funeral home for the cost of merchandise and services provided by the first establishment. And the fourth one is Public Chapter 139, effective April 17, 2017, removes the requirement that the decedent's Social Security number be included on the permanent identification device affixed to the remains of a deceased person or placed in a crematory urn.
On number one, where it says this requirement applies to all renewals on or after July the 1st, 2017, that's just the renewals on those persons that are subject to the continuing education requirements already.
That's correct. It does not, the new law or new change does not require any individuals who were not previously required to have CE to now have it. It just requires those that were required prior to the law change to now have 5 heirs of that in person. We've had some conversations with people within the department, with legal, and then also there's been some conversations with the Funeral Directors Association. It appears that what we're going to do is have an attestation form that the licensee will attest that they have completed 10 years of continuing education, 5 of those either in the physical presence of the coursework provider or through an interactive virtual program, and then we will renew their license, but at some point we will audit a percentage of those that made the attestation, and then if they cannot provide the paperwork to show that they've been in compliance, then obviously that's a violation. There would be problems there and be a complaint brought to you for disciplinary action for those. That's the way that the way it appears is going to be, and of course it's going to be implemented within the next few days because it's effective July 1, and we've got to have a plan in place to be compliant to do that. Otherwise, we've got to go back and review every request for continuation that's been approved, and those are approved for a year. So like something that was approved in first, then that's good until May the 31st of next year. So we'd have to go back and review all those requests that are still active, the approval still active, to see if they were compliance and make a differentiate between whether they're interactive or non-interactive. That would be a massive time of work, and the department believes a better way is for the licensee to do an attestation, and that make sure that when they, and there's going to be some complaints from people who said, well, I got my 10 hours of continuing education 6 months ago, and I did it all online. I didn't do anything that was interactive. So they're going to need, those people will need to take 5 additional hours, and they're not going to be real happy. But the law says that the requirements apply to all renewals on or after July 1, 2017.
That auditing process, will that be done through your office, through field reps, or?
Most likely through our office. That's the way that accountancy, and Ms. Mosby's familiar with some other boards that do it as well. It's my understanding, like 3 months, 6 months later, something like that, you would take 10%, 15%, 5%, whatever a fair representation would be, to send a letter to them and let them produce their records to indicate that they've. We'll obviously check with some of the other programs that have been doing this in the past to see what the best practices are to do that.
There's really, the way this is written, there's no allowance for any grace period for these people. Is there?
Legal can speak to it, but what we've been told in all the meetings with legal, that it's effective for all renewals. The way the law is written, it's effective for all renewals that are on July 1 or thereafter.
In the coming months, or we'll say from July till the end of the year, is there an extreme amount that comes due during that period of time?
There's not a huge renewal. The huge renewal is on June the 30th of the even numbered years. So the large renewal will be June the 30th of 2018.
So those people they'll have a year to.
It's on a 2-year renewal, and like I say, I think the ones that will be complaining are those people who have already done their CE. You know, some people get on it real quick and get it taken care of, and others procrastinate and wait till the last minute. And you know, just difference in people. Those will be the people who will be upset.
And those 5 FaceTime hours are for the renewal period, for the 2-year period, right? Yes. Okay.
And of course, if they have 2 licenses, the funeral director and the embalmer's license, they're still just required to have 10 hours of CE. They're not required to have 20 hours of CE and 10 of those to be in person.
When do you plan on having those best practices, ironed out?
Within the next few days, we've had multiple meetings, and we wanted to talk to the board today about it and see what kind of response we got from the board. Have it in place, by July the 1st. Appears to be an attestation to be the form. Well, if they renew online, it'll just be another question that'll be asked on the line that there are already some questions that they're asked about convictions and disciplinary action and different things like that. So, but what few that do renew on paper, then it would probably be a separate form that they would sign and attest to. We've got online renewal. We don't want to cause them to have an additional burden, so we just want to add a question to those that are already there.
So when you establish those best practices, is your plan to share it with the board members and just let us know
Yes, sir. Yeah.
how we're moving?
How we're moving forward, and as to what percentage we intend to audit in those.
What that looks like.
I would just like to say it will be up to each individual to keep that documentation, and they would have to literally supply it to the board. They wouldn't be able to call and ask us for that information. So that's something that everybody would need to keep within their possessions when they do the attestation for that.
Get in that piece to those individuals.
So we will include that in the. I think we could include that on when we ask the question. We can put a statement there to remind them that they need to retain that for whatever period of time that it's determined they need to retain it.
That's correct. We'll make the question so that they will understand what is necessary and what they need to keep in their possession. So if they are audited, they will have to provide that to the board.
And how long they should.
And how long they
that.
should, yes,
Okay.
that's correct.
Okay, good.
Does the state associations keep records of who has done the FaceTime? Say licensee X failed to hang on to their receipts after, like say that if they've been to a convention and they're handed out these receipts, if they fail to hang on to those, is there a way that they can contact the association? Would they have a record of proof that they have attended those meetings and can get that from them?
After the conclusion of the convention, the associations, each one of them will send us a list of licensees and what events they attended. That's basically where we do our CE at, or in the past where we put in is from that list, because anyone could go in and pick up a slip. Because they have a slip doesn't necessarily mean that they've attended, but we've used the list that the associations have provided to us in the past.
Cross-reference it.
Yeah. Yes, sir. Yes, sir. Any other questions on that?
Is there an age, a time when you reach a certain age that your requirement to do continuing ed stops?
Yes, sir. When a licensee attains their 65th birthday, the next renewal after their 65th birthday, they're no longer required to do it. So basically, the people that are exempt from CE are those who were issued a license on October the 1st, 1990 or before, and those people who attain the age of 65. For instance, if someone's birthday was August the 11th of this year, and their license expired at the end of July, then they would still be required to do the CE, and 5 of those hours would be required to be interactive. If their license expired at the end of August, which would be after their birthday, then they wouldn't be required to do any CE for the renewal of their license. And if the licensees, if they have, a question of whether they're subject to it or not, well, they can contact us, or when they're having a 65th birthday especially. Sometimes that's confusing to them, so they can contact us and provide, and we'll be glad to provide the information to them and communicate with them.
Your department receiving a lot of feedback,
We are.
positive or negative?
Generally, they're not upset about the continuing education. They're upset because if they've already done the CE, then it's costing them time and money to do it again, and especially licensees whose firms do not reimburse them for CE. The cost of CE. Those are the ones that are complaining. And I understand, where they're coming from.
I do too.
They thought they were being ahead of the game and going ahead and getting it taken care of, and it's they're going to spend time and more money in complying with it. Exam administration contract, as we mentioned at the last board meeting, the contract between the Tennessee Board of Funeral Directors and Embalmers and the International Conference of Funeral Service Examining Boards Incorporated expires June 30th, 2017. Representatives of the Department in Commerce and Insurance are working with the conference on a new contract regarding the state board examination, which is comprised of 2 parts: a funeral service arts section, which is the funeral director exam, and a funeral service sciences section, which is the embalmer exam, and then secondly, a laws, rules, and regulations exam. I have made contact with the people in the department who are involved in that, and they tell me that I can rest assured that the contract is still expected to be in place by the expiration of the current contract. Of course, to be honest with you, when it's getting this close, it kind of makes me a little nervous as to whether everything's going to fall in place or not. But what would happen if it wasn't executed? Then the applicants couldn't test until the new contract's in place. So if it were to be July the 15th before it got put in place, then there would be a 15-day period that applicants could not take a state board exam or a laws and rules regulation exam. Hopefully it will be done. It's historically, these are 5-year contracts, and historically it goes down to the very last week or last few days before it happens, and most of the time it gets done before the expiration date. Occasionally it'll be just a few days afterwards.
This is normal.
It's normal.
Stressful but normal.
Yes, sir. That's a good analogy. Stressful but normal. The licensee report is a report of licenses administratively approved by the executive director pursuant to board authority for the period of May 9, 2017 through June 12, 2017. and you see the list of establishments. Most of them are name changes. There are some individuals who have been licensed as well. Closed establishment report. There's one establishment that's reported closing since the last board meeting. That's Simple Unique Cremation and Funeral Service, which was located at 5226 Main Street, Suite D1 in Spring Hill, Tennessee. We've been contacted in the last few days about a couple other establishments that are planning to close, but they've not done that yet, so we'll report those as they.
Not that it's that important, but do you recall how long that establishment has been in business?
Well, it started out in Franklin, Tennessee under a different name. And then they did a change of name and a change of location to Spring Hill, I want to say just 3 or 4 months ago, maybe 6 months ago. I know time gets by quickly, but it's not been very long ago till they moved to Spring Hill.
Same ownership, though, right?
Same ownership.
Total of probably, what, 2-3 years, maybe?
It's been longer than that since it was in Franklin. It was in Franklin for probably there for 5 or 6 years, something like that. But it's only been this location for, I want to think, just 5 or 6 months.
Okay.
Disciplinary action report. This is one of the very few times that we will report to you that there are no consent orders that have been administratively accepted or approved. So that's one of the few times that where it's none, but in this case it is.
Good thing.
That's a good thing. That means that not that many violations. A complaint report for June 13th board meeting. Number of complaints. As of yesterday, there were 10 that were funeral director and/or embalmer, and 41 that were establishment, for a total of 51. And I want to mention to you that on was it April the 1st or May April the 1st, we went to all the regulatory boards are going to centralize complaints. And what that means is there's a group of people that's called centralized complaints that actually opens the complaints for all boards. I think there are 22 or 24 regulatory boards. And so that group of people has an executive director, and that executive director oversees centralized complaints in the customer service center. So they use a somewhat different process than what we have used in the past. So in the past, when we had a complaint, say for instance, if it was against my funeral home and against me as a funeral director and embalmer, in the past, in the board office, we opened that as one complaint with 3 respondents. The establishment would be respondent number 1, my funeral director's license would be respondent number 2, and my embalmer's license would be respondent number 3. Okay, in the new process with centralized complaints, that's going to be 3 separate complaints, but related complaints. So when legal presents them to the board, instead of them saying this is complaint number so-and-so with respondents 1, 2, and 3, they'll say these are 3 complaints that are all related. They'll be separate but related. So it shouldn't make any difference in how the board considers it, but what it will do in the old way or in the previous way we were doing it, there would have been 11 complaints reported on this report. In the new way, if that scenario played out, there would be 33 complaints instead of 11. So it will increase the complaint numbers somewhat, and each month we look at how many complaints were opened and how many complaints were closed, and it's always a good thing if there's more complaints closed than there are opened. Now, this past month we had 13 complaints that were opened in funeral board, and we didn't have that many closed, so that will also, if you have a couple of months where they're more open than they are closed, and there are a lot of factors that go into closing complaints. You know, when the board does a consent order with a civil penalty, I mean, as you know, that's an offer to settle. The licensee doesn't always take that offer, or the unlicensed person doesn't always take that offer. So it means in times they're going to be required to have a formal hearing. So it depends, you know, on there are a lot of factors that go into it, but we do watch each month to see how many complaints are opened and how many are closed. And Mr. President, unless there are questions, that concludes my report.
Motion to accept the director's report.
Second.
Motion by Mr. McKinney, second by Mr. Duffer. All in favor say aye.
Aye.
Opposed? Next item on the agenda would be approval of license applicants, individuals.
President and Board, there's one person, Mr. James Byron Collins. Mr. Collins, if you would, come up and have a seat there, and when you speak, speak loud enough that the red light on the microphone is on. Mr. Collins is from Memphis, Tennessee. He's seeking a funeral director and embalmer license, and the board may wish to consider, among other applicable laws and rules, TCA 62-5317, and making a determination whether the applicant meets the requirements for this license. Mr. Collins, if you will, address the board, tell them your name, and give them some information as to why you want to have this license today.
My name is James Collins. I'm from Memphis, Tennessee. I'm also a Baptist pastor. I became interested in the death care industry in the year of 1968 after the assassination of King. Mr. R.S. Lewis, who was the owner of R.S. Lewis and Sons Funeral Home, I questioned he and another gentleman that did the preparation work on Dr. King, and I became very interested in the business. Something I did not pursue for a number of years, but that desire to be in the profession remained. And during the aging process of Mr. Lewis, I actually wanted to purchase R.S. Lewis and Sons Funeral Home, which was directly up the street from Progressive Baptist Church, to continue Mr. Lewis's legacy. What else did you want to know, sir?
Whatever the board wants to know, they'll be reading your material and may ask you some questions.
How long have you been working in the funeral industry?
I've been working at it for about 10 years now, and I decided that if this was something I was going to continue to do, I wanted to do it right.
On your application, you had marked number one where that you had some issues with the law, maybe in what year was that?
1997.
97. All right. You hadn't had any problem since 97.
No, sir.
Okay. And there was one other that you answered yes. Have you ever had a license or applied for a license that was denied, suspended, or revoked? Or are you talking about your what kind of license are you talking about there? You marked yes on that one. Have you ever had a license or applied for a license?
Not a funeral license, but my driver's license.
Oh, okay. Okay. All right.
That's what you were referring to?
Yes, sir.
Okay. I understand.
Mr. Gribble, what's the difference between page 11 and page 15? Was it just resubmitted, or is that the same form?
Same form, it was submitted at different times and had different markings on it, and I guess, for lack of a better word, out of abundance of caution, this past Friday, there was the last final amended one was filed with us, and I think that's what probably Mr. McKinney was kindly referring to. At one point, one is marked one way and one another way.
The license question?
Yes, sir.
Okay.
The last one that's filed with us is at the very beginning, which is stamp dated by the board stamp there on June the 9th, and it just answers yes to question 1.
Okay.
So that I might understand correctly, this application has been submitted more than once?
Yes, sir. It's the same application, but I guess a revised copy or an amended copy of the application has been submitted.
They were just, what, a month apart?
Month and 5 days. One was submitted or received. One was received on May 4 and one on June the 9th. And older one that Mr. Cochran referred to may be older than that. Sometimes when an applicant submits the application, they don't. There's sometimes a question they don't answer or they fail to answer, something like that, and instead of them sending us a letter saying this is the answer to question 4B, we ask them to submit an amended application. That way they attest under one form on that particular date, this is what I'm attesting to the board.
Collins, you're employed with MJ Edwards
Yes,
currently,
sir, I am.
today?
Yes, sir.
That's where you served your apprenticeship too.
Marshall. I did some at NJ Ford and Sons, and I left and went to MJ Edwards.
I see that now.
Leave your training, your schooling?
Northwest.
What year did you finish there?
13 December. However, the physical graduation wasn't until May of 2014, but my degree
Graduate date says 12/17 of 2013 on your transcript.
I would make a motion to approve this application.
Second.
Motion by Mr. McKinney and second by Mr. Cochran. Any questions or discussions? All in favor say aye.
Aye.
Opposed? Congratulations, Mr. Collins.
Thank you.
Congratulations.
Thank all of you.
You couldn't tell from back there, but we had like 40-something pages to look through. Congratulations.
Thanks. Yeah.
You come right ahead.
President, there are no establishments to appear before the board today.
New business.
That time of the year again, for a legislative board member has a suggestion or something for consideration, if they would email that to me, then I'll get it to legal, and Ms. Hooper can look at it then, and we can make the proper communication that we need to make. Basically, just a reminder is how this works. This is basically a call from administration to say, does this board have any legislation they want to propose to be included in the governor's packet to be presented to the legislature when they reconvene in January. So the department has a packet that they present to the governor's office, and in that packet, of course, keep in mind there are several divisions within Commerce and Insurance, fire division, insurance division, manufactured homes, I'm not sure what all, but then the regulatory boards, and now the regulatory boards, there are 22 to 24 regulatory boards. So I guess the best way to say it is there has to be compelling reasons to have a submission for a request, because the competition's pretty great to get included in the department's package, which is approved or reviewed and then later approved by the governor's office and included in that package. Usually if there's something that if the legal says there needs to be a law changed because it's in conflict with something else, then that usually has a pretty high priority, and legal hasn't identified anything that needs to be changed because of that. Certainly submit anything you wish. But what I wanted to communicate is, because it's submitted doesn't mean that it would be included. But obviously if it's not submitted, it won't be included. So you got to, it's whatever you want to do. It's an opportunity for the board. If you think there's an issue, if you think that something is over-regulated and needs to have less regulation, and you want to change something in that way, or if you think that the board thinks there's a problem in some area and that needs to be addressed by legislation, then that's also a possibility to do as well.
Yes, and regarding that, I would ask that you all get me any proposals no later than next Wednesday. We have an internal deadline for those of next Friday, and so anything you submit, I would like to have the opportunity to meet with Mr. Gribble and talk with him about it and make sure that the forms are properly filled out, etc. So if you could have any proposals to me by next Wednesday, I would appreciate it.
That is June the 21st.
That's correct. Thank
First
you.
day of summer.
Are you still looking at rulemaking hearing?
In July?
July. Okay.
We're not sure yet. It
Okay.
just depends on a number of factors. Based on where things stand right now, that probably would not be in July.
Okay. But sometime this year, you think, to deal with
Definitely.
some of these, the laws that have been passed this year, maybe?
Definitely this year.
And then are we still looking at maybe a decrease in some some fees, hopefully.
Yes, that would need to be in the rulemaking hearing, and I would think you probably want to do that at one time in one rulemaking hearing. So we've looked at that, and tentatively, and of course, I mean, it's obviously the board's decision, but in talking to as I mentioned to you before, I meet with a financial manager for the department on a monthly basis, and the conversations that we've had regarding fee reductions is that it would probably be best to look at reducing the initial licensure fee of those individuals from $275. Well, the application fee and licensure fee together at this point is $475, and reducing that to $435 for a funeral director, and that'd be a reduction of $40 on each license for those that are applying for both licenses.
So it would help the individuals that are entering the profession, and that is, what is that, roughly a decrease of about, what, 14%, like we did the last time?
Probably I would have to put a pen and pencil to
if it's the same figures the last time the fees were lowered, it's about 14%, and that's not bad.
And we might be able to recommend to you some additional reductions, but that at the point that in the past conversations I've had with him, in the recent past conversations, those have been the only areas that we've identified that we definitely would want to make a recommendation to the board to reduce. As we've talked about, this is a year that we'll be down as far as revenues and expenses. Our expenses will be greater this year than the revenues, but then in the even numbered years, or when the revenues are greater than the expenses. However, since we reduced the renewal fees for all licensees this next year, that revenue will be lower than it's historically been in the past, because, like Mr. McKinney said, the board did reduce those renewal fees from $275 to $235 for all licensees back.
That was in 2012, and it was probably 2013 or 14 before it made its way through all the channels and went into effect.
That's a 12% decrease.
That would be the same amount, and this time it would be for those that are becoming newly licensed. And the thinking behind that is, it's probably those are the people that need the most help, because they're just starting out.
I was only off 2%.
You was close. That's $80.
Yeah.
So, and we'll have, as we get closer with the other items, it's we talk about these things, and Ms. Hooper and I talk almost not daily about possible rule changes, but we talk weekly, at least once a week, and different issues will come up. And so what started out to be a little small ball has gotten bigger, and that doesn't mean that there's going to be more regulation. It's just that things need to be explained so that the licensee understands what's expected of he or she, and it's clear. And anything that can help the licensee to understand is always a good thing. That way it removes a lot of the gray area. So that's one reason why it's been a little longer than we first thought that it would be, is we've identified some areas that need to be addressed and looked at.
And I'll just clarify, before we would have a rulemaking hearing, you all would have a meeting where you would actually review the rules, et cetera, and approve them before a rulemaking hearing. And so you would have prior notice of any rulemaking hearing, because you would have already reviewed the rules at a prior meeting.
We would have a work session or two probably before the actual public hearing.
Yes, that's correct.
And it could take up to a year for these to go in effect.
It usually doesn't take a year unless any number of changes are made, but it could take up to a year. And some rules are not by rulemaking hearing, and so some rules may be proposed rules, and those are more streamlined, and you wouldn't have a hearing, but you all would review the rules, potentially make changes, and they would be proposed rules as opposed to rules by rulemaking hearing.
Do our rules have to be approved by the legislature, a committee up there, before they go into effect?
Our rules are reviewed by the Joint Government Operations Committee, usually before they go into effect.
Questions?
Not on this subject, but do we have an update on the live stream that was mentioned a few meetings ago?
Still in the testing stages. It seems to be working well. Miss Mosby actually knows probably more about it than what I do.
Recently, we're live streaming here within the office and our field reps just to test it out. I'm going to get with our IS department to see if that's something we can get out to the public earlier so they'll be able to as a permanent streaming address.
I will mention, and should have mentioned this in my report, but a week ago, yesterday, I had the opportunity to go to the Tennessee Funeral Directors Association convention, which was held at Murfreesboro. And then yesterday, Ms. Hooper and I both were able to go to the Tennessee State Funeral Director and Mortician Association meeting, which was in Chattanooga. It gave us the opportunity to be out among the licensees and to hear comments, and that has been something that people have said in a positive way, that they do like being able to view the board meetings. And when we mentioned to them the possibility of live streaming, they like that even better. So it would be in real time. We'll see. We have to get, I guess, clearance or approval to do the live streaming, but Ms. Mosby will follow up on that, and we'll see if maybe in the next meeting we can do that.
And a motion to adjourn.
Motion.
Second.
Motion by Mr. Duffer, second by Mr. McKinney. All in favor say aye.
Aye.
Opposed? Thank you everybody for coming.